lock, and now the tenant can no longer access the garage. They still have access to the house, however. This is called a partial actual eviction. It's an actual eviction because the tenant is physically barred from access to some of the space. It's partial because the tenant can still get access to the house, they just can't get access to the garage. Now, obviously, this is a breach by the landlord of the implied covenant of quiet enjoyment, because the covenant is that the tenant will have access to the entire space. But the amazing thing about this particular kind of breach, where the tenant is denied physical access to part of the space, is that the tenant is now excused from paying all rent on the house and the garage until they're restored to the entire space. The common law had a quaint way of putting that. They said that rent is not apportionable as to space. And what that meant in that quaint way of speaking was that if you don't get all of your space, you don't have to pay any of your rent. So literally, the tenant can occupy the house rent-free until the landlord restores the garage to them as well. Now here's another application of that principle that a landlord has a duty not to deprive the tenant of any space. Let's suppose that the bank holds a prior mortgage on the property. That is, the landlord put the mortgage on the property before the landlord leased the property to the tenant. Now, let's suppose after the tenant moves in, the landlord defaults on the mortgage loan to the bank forecloses the mortgage, and the bank dispossesses the tenant. The bank, of course, is perfectly entitled to do that. Does the tenant have an action against the bank for doing so? Not at all. The bank is only doing what the bank is entitled to do under the mortgage. What about an action by the tenant against the landlord? Well, the answer pretty clearly here is yes, because what the landlord has done is to fail to make the mortgage payments, the result of which is to dispossess the tenant. So the landlord has really breached the covenant not to deprive the tenant of any space. The landlord's actions have deprived the tenant of all of the space, and therefore the landlord is going to be liable to the tenant for damages, and of course the tenant can also terminate the lease. Now, sometimes people wonder about a third party by the act liable for damages because a criminal has come into the property. Not at all. It's different than the covenant to remove previous tenants, because in this case, the criminal is not a party who was put into possession originally by the landlord. So the landlord has no responsibility for the actions of third parties. Now, I have to caution you that in a number of modern cases where the area is a high crime area and the landlord is aware of criminal activity and doesn't take adequate precautions to secure against it, sometimes the courts have found the landlord liable, not under the implied covenant of quiet enjoyment, but simply because the landlord was negligent in behaving in a way that allowed criminals to come in and harm a tenant. Fine. A constructive eviction? Well, it might be. It depends on whether action by the landlord is required, either by the language of the lease or by applicable codes, such as a housing or a building code. If the landlord has a duty to take action, either under the lease or under applicable codes, and the landlord fails to take action, the court will almost certainly find a constructive eviction on these facts. So inaction as well as action can result in a constructive eviction. Sometimes to summarize our discussion of the implied covenant of quiet enjoyment, it includes 4 sub-concepts. The first is that the landlord has title or the right to lease the space to the tenant. The second is that the landlord has a duty to remove previous tenants so the new tenant can get unencumbered possession of the property. Number 3, it includes the idea that the landlord won't deprive the tenant of any of the leased space during the term of the lease. And number 4, the landlord will not unreasonably interfere with the tenant's possession by causing a constructive eviction. That concludes video number